I'm Calvin Koo, and this is your May 2023 crypto update. As a reminder, my thoughts and comments are strictly my own and not that of my employer. Nothing I say is intended as legal or financial advice. This month, let's focus on regulatory developments in 3 different continents, giving some suggestion of where we sit globally following a year of crypto winter. Starting in Europe, last month, European Union parliamentarians approved what has been called the world's first comprehensive package of cryptocurrency regulation rules. Specifically, it passed the Markets in Crypto Act, or MiCA, which is aimed at regulating crypto transfers in Europe, with a particular focus on consumer protection, including seeking to protect against market manipulation and financial crime. After the EU Parliament's approval, the process moved to the EU Council, which approved it in mid-May, meaning it now will be published in the official journal of the European Union and then come into effect 20 days after that. Reportedly, the publication is likely set for June, meaning the law takes effect in July, with some aspects kicking in over the next year to year and a half. So, for any viewers that provide crypto services in Europe, please speak with your compliance and legal teams about what steps are needed. This is because MiCA's focus places most of the responsibility on crypto service providers. As we've discussed before, traditional finance deputizes financial services companies to help protect consumers and the system against crimes like money laundering and fraud. So it was natural that lawmakers, following guidance from the Financial Actions Task Force, again looked to service providers to help regulate the crypto market. For now, as those service providers remain an important backbone of the industry, notwithstanding many preferring a decentralized approach, this way forward seems to make practical sense for a lot of regulators, including in Europe. Thus, service providers like crypto exchanges and token issuers must now meet certain requirements for transparency, disclosure, and supervision of transactions. This is intended to give consumers more transparency and information about various risks, costs, and charges associated with transactions. On the anti-money laundering front, the EU also approved legislation for tracing crypto transfers. The idea is to ensure that all transfers can be traced and suspicious transactions blocked, applying the travel rule common in traditional finance. As discussed in previous videos, this means information on the source of asset and its beneficiary must be included with the transaction. We've said before that some in the industry question how this can be applied to self-hosted wallets, meaning those not held in custody by centralized exchanges. The EU has nevertheless said that the travel rule must still be followed, even when hosted wallets managed by service providers are dealing with self-hosted wallets. However, purely person-to-person transfers without using a service provider do not need to follow the travel rule. Ernest Urtasun, a reporter for the Economic and Monetary Affairs Committee on Crypto Asset Transfer, said, quote, "Currently, illicit flows in crypto assets are moved swiftly across the world with a high chance of never being detected. The recast of the transfer funds regulation will oblige crypto asset service providers to detect and stop criminal crypto flows, and also ensure that all categories of crypto companies are subject to the full set of anti-money laundering obligations. This will close a major loophole in our AML framework and implement in the EU the most ambitious travel rule legislation in the world so far, in full compliance with international standards," end quote. Our next story, moving on to Asia. Now, we've talked before about what Hong Kong is doing, actively courting crypto businesses to come to Hong Kong with new legislation and an expanded licensing regime that has created a cautiously optimistic buzz in the city. Time and again over the last few months, we've seen various members of the Hong Kong government talk about their support for crypto and Web3 economies. Most recently, the Hong Kong Monetary Authority, or HKMA, which regulates banks in the jurisdiction, affirmatively reminded banks last month that they should not simply refuse to open accounts for crypto-related businesses simply because of their crypto background. To the contrary, the HKMA reiterated that there is no legal and regulatory requirement prohibiting banks from providing such services, and that they should use the usual risk-based approach when doing anti-money laundering customer due diligence, rather than a one-size-fits-all approach which might reject applications such as those from new industries solely on the basis of it being a new industry. To be a little bit more illustrative, the HKMA release provided some observations and good practices identified in the onboarding of corporate customers. In one example, the frontline staff of an institution rejected upfront an account opening application upon learning about the applicant's business nature. The HKMA said that the expected standard was that there should be no such outright rejection in view of the industry. Instead, the risk-based approach should be followed, understanding and differentiating the relevant risks involved in that particular case. The next observation said that an institution conducted additional customer due diligence measures for a virtual asset service provider that had already been licensed by the local Securities and Futures Commission, or SFC. The HKMA said the expected standard, however, was that such additional diligence wasn't necessary if the provider was already SFC licensed. Extra customer due diligence is only applicable to providers providing correspondent services to overseas providers. One more. An institution required an SFC licensed virtual asset service provider wanting to open a bank account to furnish an independent assessment report on that provider's systems and controls regarding anti-money laundering and terrorist financing. The HKMA said that the expected standard was that as an independent report can be costly and time-consuming, the information collected by applicants should be reasonable, taking into account the circumstances of the applicant, such as the fact that the virtual service provider already has a status as a legal entity under the SFC supervision. This, of course, already comes with having passed certain regulatory requirements through the SFC. So all of this seems like a concerted effort by the HKMA to get banks to take something other than the most conservative approach when dealing with new industries like crypto. It's hard not to see this as a part of the government's ongoing effort to support the crypto industry, albeit in a way that still adheres to existing regulations and guidelines. Now, perhaps unfairly, but it's difficult to ignore the contrast here with the perception among many in this industry from the events earlier this year when US regulators were shutting down banks that had large crypto-related customers. Now, while that initial view that the regulators in the US were specifically doing so because of the crypto customers, that view has now changed. Perhaps it was overblown at the time as the banking issues in the US appear to have had other fundamental problems, but perception can definitely fuel reality. And here you have one sophisticated financial jurisdiction in Hong Kong that appears to be actively trying to support the industry, in contrast to what was a pretty popular view in the US about being anti-crypto and using banking services as one way to go against it. Again, that was potentially overblown, but that was the perspective among many in the industry. Now, two other brief updates from Asia. First, sticking with Hong Kong, the Securities and Futures Commission last week said it had concluded its consultation on the regulation of virtual asset trading platforms, with a significant majority of respondents agreeing to the SFC's proposal to allow licensed trading platforms to serve retail investors. The SFC says it will implement a number of robust measures to protect retail investors, including ensuring suitability in the onboarding process, good governance, enhanced token due diligence, admission criteria, and disclosures. The SFC then published its revised anti-money laundering and counter-financing of terrorism guidelines, including a new standalone chapter for guidance in relation to virtual assets. These take effect on June 1st. On the anti-money laundering front, Japanese lawmakers have also reportedly decided to enforce stricter AML measures, namely the travel rule requirements, beginning June 1st. Now, moving on to another small jurisdiction, different continent, this time in the Caribbean. Before crypto winter, the Bahamas was actively courting crypto businesses. This approach drew some attention in the wake of the FTX collapse, which famously had a Bahamian presence, with some wondering whether the country would change course on its crypto regulation. We now have a better idea of its perspective. The Bahamian Securities Commission announced in late April that it was publishing the Digital Assets and Registered Exchanges, or DARE, Bill 2023 for consultation. The Bahamian government said the bill expands the definition and list of digital asset business activities and includes robust customer investor protection, risk management, and market innovation and development provisions. Specifically, The bill strengthens financial and reporting requirements for digital asset businesses and requirements related to custody and custodial wallet services, operating a digital asset exchange, providing advice on and management of digital assets, provision of staking services, and a comprehensive approach to the regulation of stablecoins. The bill aims to become effective at the end of Q2 this year. So this is a follow-up to the DARE Act 2020, with the Commission saying it has taken feedback about the 2020 Act and also monitored developments in the industry, including international regulatory advancements. In particular, it said it looked at comparable frameworks in the EU, Hong Kong, and New York, and then worked on filling in legislative gaps and concerns from the previous setup. So in general, the 2023 bill captures a wider range of digital asset activities. It requires exchanges to ensure adequate systems and controls, and notably lack of systems and controls was one major critique by FTX's liquidators of the prior company management. The bill provides what it calls a robust approach to safekeeping and returning custodied assets. And again, it's hard not to hear FTX echoes in this. It creates mandatory disclosures for staking businesses. It allows for voluntary registration of digital asset issuers outside the Bahamas, and it establishes a new framework for stablecoins, including a new definition, specified forms of reserved assets, and new requirements for custody, management, segregation, reporting, and redemption. Algorithmic stablecoin issuance is prohibited. The bill also regulates non-fungible tokens if they are financial in nature, and it prohibits issuance of privacy tokens. The Commission is soliciting public feedback on this through May. So in conclusion, let's go back to where we started today, and I want to read out another quote from a different EU parliamentarian, this time about the European MiCA bill specifically. Stefan Berger, who's the lead MEP for the MiCA regulation, said, quote, "This puts the EU at the forefront of the token economy with 10,000 different crypto assets. Consumers will be protected against deception and fraud, and the sector that was damaged by the FTX collapse can regain trust. Consumers will have all the information they need, and all underlying risks around crypto assets will have to be monitored. We secured that the environmental impact disclosure will be taken into account by investors in crypto assets. This regulation brings a competitive advantage for the EU. The European crypto asset industry has regulatory clarity that does not exist in countries like the US." Now, that last line of the quote notably contrasts the EU approach with the lack of clarity in the US. It'll be interesting to see how this regulatory development and those in other parts of the world we've discussed affect crypto businesses and policies in the US. Will the businesses there be inclined to move out of the US? Can they really ignore the US market? Will the US policies evolve in line with the global standard? Now, the passing of MiCA is not going to create any immediate changes in the US. MiCA's approach has been public for a couple of years, and the progress of other jurisdictions like Hong Kong have been similarly transparent over the last year. But if the regulatory regimes in Europe, Hong Kong, the Bahamas, and elsewhere seem to work well, then might the US follow? How long will it take to settle that question, if ever? Those operating in the US likely don't want to wait that long, as they've been clamoring for clarity for years now. But no doubt those operating in the US are also seeing how much of the world is finally moving ahead with regulation, to the frustration of those still eyeing that lucrative American market. That's it for this month. See you next time.